May I please, Lordships?
Yes.
My Lord, I'm mentioning on behalf of my senior in item number 5.
Item 5.
My Lord, we are yet to file affidavit in reply, so two, 2 weeks time may be given.
You are mentioning on behalf of
Ejo,
Ezo.
my Lord.
Affidavit in reply.
Affidavit in reply, my Lord.
Mr. So-and-so makes a mention on behalf of Mr. Ezo, the learned counsel for the petitioner, and 6 for 2 weeks time
My Lord, there is an interim.
to file affidavit in reply. Prayer is allowed, listed after 2 weeks. The interim order passed earlier shall continue till the next returnable date.
Much obliged, my Lord.
Please, my lords.
Yes.
Lordship, I have filed one IA in item 4, that is criminal appeal jail 9 of 2022, praying for suspension of sentence. I have filed it yesterday. If it may kindly be listed, my lord, this morning. At this stage, my lord, I believe only notice will be issued. And
It is listed.
it is not listed, the IA, my lord. However, the main appeal is listed. So if the IA can also kindly be called.
Item 4.
Item 4, my lord.
What is IA 121?
Yes, this is for delay condonation, my lord. Another IA I have filed praying for suspension of sentence. Yesterday, my lord. There is some problem, my lord, with regard to service of notice upon the respondent number 2, my lord, which is why, if it can kindly be listed with the main appeal, my lord. Oblige, my lord.
Please, your lordships,
Yes.
I beg to mention hearing item number 10 to 13.
10 to 13.
Yes, your lordship.
Yes.
Kindly list this matter after 2 weeks. My senior has some personal difficulties.
10 to
13.
for the respondent,
Yes, your lordship.
Mr. So-and-so, the learned counsel for the respondent seeks adjournment of the case after 2 weeks on the ground that the counsel in the case has some personal difficulties. Prayer is allowed, listed up to 2 weeks.
Oblige.
May I please, Your Honor? Your
Yes.
Lordships, I beg to mention item number 9.
Item,
Number 9.
yes.
My senior is out of station, so
Who is your
maybe
senior?
Neteo Kosa.
Okay.
Your, may it be listed after 3 weeks.
This is with item 8.
Item, yes.
With item 8.
Lordship, I'm referring in item number 8. I'm the appellant here in item number 8.
Yes.
This is an analogous matter.
Yes.
May it be listed after 3 weeks.
These are analogous.
Yes, Lord.
MS so-and-so, the learned counsel for the petitioner in criminal appeal J 4/2020. 6 adjournment of the case after 2 weeks. Prayer is allowed, listed accordingly. Okay.
Lodge.
Oblige.
May it please, Lordships.
Yes.
Lordship, I beg to mention item number 3. Lordship, as per the office note dated 12/6/2023, Lordship here, service of notice served upon respondent number 2 is still awaited. So
Let us see the record. Let it come up as per the list.
Okay, Lordship.
For motion, item number 1.
May I please, Lordship, the IA has been filed under Section 389 of the Code of Criminal Procedure, praying for suspension of the interim judgment dated 22/11/2022, and to grant the appellant on bail, Lordship.
about the suspension of sentence?
Your Lordship, I bring for suspension.
No, you are praying only for suspension of judgment and order.
Yes,
Just see,
yes, 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 Lordship.
just see your prayer.
Yes, Lordship. Impugned judgment dated 22/11/2022.
Yes, what about suspension order?
Lordship, I mean, I'm not to 8 also.
No, you have to file an amended petition because actually, like, as per
Yes,
the new
Lordship.
notification, we cannot allow that.
Yes, Lordship. Amended, Lordship, I mean, allowed to, Lordship, amendment only. So again,
Yes, yes, we will allow, we will allow. Mr. Limawaba, the learned counsel for the appeal, submits that he may be allowed to file amendment and petition to the course title,
post that in the prayer, Lordship.
to the course title and the prayer of the present I. Where is the law? Listed up there.
After vacation, Lordship.
Listed up. Tara tari. This is
Exactly, Lordship.
For motion, item number 14.
Yes, Mr. Yamawati.
Worship, this writ petition has been filed against the order dated 31/3/2023, passed by the gate. Passed by the gate, Worship. Worship, the respondent, the sole respondent, she was appointed as work Sahayika under the military hospital.
She was terminated.
Yes, she was
She was
terminated.
terminated.
Her service was
Where
terminated.
is the termination order?
Page 28, Worship.
28.
Start from page 27, Worship. The only,
This is the order passed by CAT.
yes, Lord.
Where is the order passed by the
Termination.
authority?
Okay. Page 26.
26.
This is the movement order.
Which is dated
11 August 2017.
But see the order passed by CAT.
Yes,
See
Lord.
page 36.
Yes, Lord.
Yes, the termination order is 22/7/2017. It is not 11 August.
This is a recommendation, Lordship. Recommendation of the court, 22/7. At page 25.
Your termination order is page 25.
Yes.
The
Page
board
8.
recommends that Ward Mamta Sahayakia,
Yes, Lord.
Mamta Kumari be removed from probation and termination with effect from 11 August 2017. So 11 August 2017 is only a consequence of 22 July.
22 July, yes, Lord.
Third, Mr. Yamawati,
CC.
the Leonard CGC. For the petitioners. The present writ petition has been filed. Impugning the order dated 31/3/2023, passed by the Learned Central Administrative Tribunal, Gauhati Bench, Circuit Court at Kohima, quashing and setting aside the order dated 22/7/2017, passed by the appellant authorities, terminating the service of the respondent who is serving as ward Sahayika under which, under the respondent number 2.
Yes, Worship.
Under the respondent number 2. No.
Oh,
Under,
it will be 3, Lordship, since she is in Angabahar.
under the
Respondent 3.
Brigadier R.N. Agarwal, Brigadier within Brigade Medical, Headquarter Eastern Command, pin 908542, care of 99 AP. Stop. Issue notice to the respondent, returnable within 4 weeks. The learned counsel for the appellant, for the petitioner, shall take steps for service of notice upon the respondent by registered post with AD within a period of
2 days, Lordship.
within a period of 2 days from today. Okay. Okay.
What's up?
For motion, item number 50.
Peace Lordships.
Yes.
Lordships, the petitioners are serving as scheduled laborers, Lordship. They were granted temporary status. They are employees of the BSNL, Lordship.
Yes.
Lordship, my prayer in this read petition is there's a scheme formulated by the Ministry of Telecommunications, Lordship, in the year 1989. As per the scheme, they are eligible to be considered for regularization, Lordship. And the scheme also provides for granting temporary status to all the casual laborers, Lordship. The scheme specifically provides that till such all the casual laborers are regularized, Lordship, no fresh appointments should be made, Lordship. We are serving for more than 26, 27 years in the department, Lordship. I may be allowed to take your Lordships to the scheme, Lordship. Page 29, Annexure 1, Lordship. This is issued by the Department of Telecommunications, Lordship. One, regularization of casual laborers of Department of Telecom and conferment of temporary status. Scheme for conferring temporary status on casual laborers who are currently employed and have rendered a continuous service of at least 1 year have been approved by the Telecom Commission. Details of the scheme are furnished in the annexure. If I may be allowed to take your lordship to the annexure, lordship will find it the next page, lordship. Provides a detailed policy of the government, lordship. Page 30, lordships. Casual laborers grant of temporary status and regularization scheme. One, thus this scheme shall be called the casual laborers grant of temporary status and regularization scheme of the Department of Telecommunications 1989. Two, the scheme shall come into force with effect from 1/10/1989 onwards. Three, the scheme is applicable to the casual laborers employed by the Department of Telecommunications. Provisions. Four, the provisions in the scheme would be as under. A, this is important, lordship. Vacancies in the Group D categories in various offices of the Department of Telecommunications would be exclusively filled by regularization of casual laborers, and no outsiders would be appointed to the category, except in the case of appointments on compassionate grounds, till the absorption of all existing casual laborers fulfilling the eligibility conditions, including the educational qualifications prescribed in the relevant recruitment rules. However, regular Group D staff rendered surplus for any reason will have prior claim for absorption against existing future vacancies. In case of illiterate casual laborers, the regularization will be considered only against those posts in respect of which illiteracy will not be an impediment in the performance of duties. They would be allowed age relaxation equivalent to the period for which they have worked continuously as casual laborer for the purpose of age limits prescribed for appointment to the grade D category if required. Outside recruitment for filling of the vacancies of Group D will be permitted only under the condition when eligible casual laborers are not available, lordship. The scheme is very clear, lordship.
After the order was passed by CAT,
Lordship.
have you approached the authorities?
Lordship, the speaking order was passed by the authorities, lordship. I'm also imputing the speaking order, lordship. We'll find the speaking order at page 174, lordship.
So is it not proper for you to approach CAT against this order?
Lordship, I'm also partly imputing the decision of the CAT, lordship. It was rendered in the year 2015. However, the respondents, that is the BSNL, being aggrieved, they have filed a writ petition before the this Honorable Court at Division Bench, lordship.
What
Now,
was the outcome?
while pending, lordship,
They
they
have
have
withdrawn.
withdrawn. They have withdrawn in the year 2021, lordship.
They have withdrawn.
They have withdrawn, lordship.
Thereafter,
Thereafter, the speaking order was passed, lordship.
you think of it, because I think you will have to approach the CAT again against the speaking order.
Lordship. In this petition, lordship, I'm partly impugning the decision of the CAT, lordship. For that reason, lordship, I'm before this Honorable Court, lordship.
CAT has decided the matter. Due to non-compliance of the CAT, you have approached the Honorable Division Bench.
Lordship.
The order was passed by the
Lordship.
Honorable Division Bench.
Lordship, if this matter may be listed, lordship, in this meantime, lordship, if I may be allowed to.
You get instructed.
Lordship.
Okay. Well, think over and come.
Lordship, lordship,
Okay.
lordship.
Listed again on.
5th of July, Lordship.
Listed again on 5/7/2022. Just think over it.
Lordship. Much obliged, Lordship.
Unlisted motion. Item number 16. Unlisted motion.
May it please, my lords. This unlisted motion, lordship, it is connected with item 4 in today's list, my lord. Now, lordship, here I have implemented the respondent number 2, who is the father of the victim and the complainant in the FIR, lordship. The IA is praying for the suspension of the sentence, lordship, imposed upon the applicant, lordship, by judgment and order dated 22/10/2021, passed by the learned special judge, fast track court, Dimapur, Nagaland, lordship. Now, my lords, in the
Which is that sentence? Which page?
annexure A, lord, 1, lordship, page 10.
What is the sentence?
15 years, lordships.
Under which
Rigorous
one?
imprisonment
Under
under
which?
354 as well as 376 to 1 Indian Penal Code, read with section 4 and 12 of the POCSO Act, lordships. Today, lordship, I am merely praying for the issue of notice, lordship, upon the state as well as the respondent number 2. The operative portion is at page 24, lordship. In the IA.
Art, Mr. Simply Amar. The then counsel for the applicant. This application has been filed under section 389, clause 2, 389, clause 2 of the Criminal Procedure Code 1973, praying for suspension of sentence awarded by the judgment dated 22/10/2024. Issue notice to the respondents, returnable within 4 weeks. Stop. Since Mr. K. Angami, the learned public prosecutor, represents the state respondent, no formal notice need to issue. The learned counsel for the applicant furnish requisite copies of the application to the learned public prosecutor in the course of the day.
Lordships.
Insofar as the respondent number 2 is concerned, the learned counsel for the applicant.
Lordship, here I have been facing problems, which is why since, despite the fact that the criminal appeal has been filed last year, I am still at the order stage. We have taken steps to register AD through the police also, Lordship, and we have taken out the address from the documents that the prosecution has furnished to us in the FIR information memo, Lordship. However, approached we have approached that particular address, Lordship, but the complainant is no longer residing there. No one in the vicinity is aware of the address. Even the police have tried their best to pick out the address of the complainant, that is the respondent number 2. So if, Lordship, if there is any possibility that the applicant as well as the appellant, Lordship, here may be allowed to take steps by substituted notice. That is the only,
Okay, first you take steps by registered post. Let's see after that.
we have already exhausted that, Lordship.
In this application.
My lord.
Insofar as the respondent number 2 is concerned, the learned counsel for the applicant will take steps for service of notice upon the respondent number 2 by registered post with AD within a period of 3 days
Lordship.
from today. Only after that, let's see the next
Lordship.
listed after points.
Applied, Lordship.
For admission, item number 2.
May it please your lordship,
Yes,
I'm standing on behalf of my senior Joshua.
yes.
If your lordship may kindly refix this matter for admission herein after 1 week, lordships.
Mr. Sansu. Makes a mention on behalf of Mr. Joshua Shakti, the learned counsel for the petitioner, and seeks a journal of peace after there is a listed of the
God bless you, lordship.
For order, item number 3.
May it please the Lordships.
Yes,
My lord, as per the notice, office note dated 12/6/2023, Lordship, here service of notice served upon respondent number 2 is still awaited, Lordship.
So let this matter be listed after 3 weeks.
office code 12/6/2023. Replies that depends on his report on responding to the waiting. Details of the report, listed after 2 weeks.
Thank you, lordship.
For order, item number 4.
Please, my lord. Here, Lordship, I have taken steps by registered AD as well as custody to the officer in charge of the police station concerned, that is the Women PS Dimapur, Lordship. However, I am till date unable to effect notice upon the respondent number 2.
When I will that
After 4 weeks, Lordship.
listed on our
IA Criminal 8
IA criminal 8
of 2023.
of 2023 after 4 weeks.
Applies, my lord.
For hearing, item number 7.
Yes, Mr. CP. Some good news.
Certainly,
Mr. CP.
certainly, Lord.
Very good.
On 17/3/2021, my learned friend and I have been appointed as mediator under Civil Procedure Mediation, Gauhati High Court Rules 2007. Although the period of limitation is only 6 months, however, considering the complicated issues, time has been extended, and then on 24th of this month, that is Saturday, the parties have signed, executed the settlement agreement, and I have a copy of the agreement, enclosing a map also, and a program of the settlement is also enclosed. One original is one, and then one Xerox copy for perusal of this honorable court, and also to place it and record about the settlement. Lordship may have seen in the newspapers also, it was widely
this court, in the interest of justice, will have the power to condone the 60 days.
My lord, that issue is there, but then, my lord, we have been making submissions, and therefore, in the
You have been
From time
granted
to time.
extension
yes,
from time to
in fact, my lord, as many as nine times it was extended. So every time we were coming back to this honorable court to seeking extension. Accordingly, this honorable court, in view of the peculiar situation, because it was a very complicated issue, that's how this honorable court, in the larger interest of justice, was granting extensions. Of course, 60 days and beyond 3 months, that issue is there, but my lord, in the larger interest,
In view of complicated human character, at one point of time, the parties have already arrived to a settlement. Again, after some time, some development will take place. That's how the matter got deferred from time to time.
Lordship,
Wait.
one after we prayed, we went to the spot for demarcation of the boundary at one stage. Then differences arose on the ground. So we could not demarcate the area. And then we were back to square one again. So those were the circumstances under which we were working on this issue. And it's not a question of two villages, but it's a question of two tribes, Angamis and Sumis. So the history behind is both sides are equally right.
Nobody's wrong.
Nobody's wrong. One would speak, in a very gentle manner, but not touching an inch. The other side will speak a little bit louder, and same, he will not touch an inch. That was the situation.
I think the louder one belongs to my tribe.
And then last 85 years, though there was no bloodshed, there were also, physical fights and all that. So the question of, and the older generations, it was very hard for the older generation to come to terms. So that way, to forget and forgive all this bitterness, Lordship, it took little time.
So we actually, in our order, we incorporate this.
Yes, Lordship.
Yes.
In view of the out of the court settlement, let the matter be rested in peace.
Yes. By the order dated 17/3/2021, Mr. C.T. Jamir, learned counsel for the Mr. C.T.
No,
Jamir.
I was not the counsel
Yes,
earlier.
you are not the counsel. Was appointed as the mediator on behalf of the appellant. Mr. C.T. Jamir, the learned senior counsel, was appointed as the mediator on behalf of the appellant, and Mr. Tatamasa, the learned senior counsel, was appointed as the mediator on behalf of the respondents to resolve the long pending dispute, which was the subject matter of the present
Read the bill.
read appeal. By the same order dated 17/3/2021, "60 days time was prescribed for completion of the mediation from the first date of appearance. As per clause 18 of the rules of 2007. Stop. This court, however, in the interest of justice, has extended the time, has extended
Extended the time from time to time will be appropriate, I think.
has extended the time beyond 60 days from time to time so as to enable the mediators to resolve the dispute. So today when the matter is listed, both the mediators appears before the court and has submitted the voluntary dispute settlement between
Pirima and Pipima.
the appellant and the respondent of each, namely
Pipima is the appellate.
Kama and Erevan village. Which is dated 24/6/2020. What can this be called the terms of compromise?
Amicable settlement out of the court. Settlement, amicable settlement outside.
Stop the boundary dispute settlement
Through mediation.
through mediation between the parties is incorporated as follows. See. Hold this.
Let the settlement agreement may form a part of the record of the case.
Yes, yes. In terms of this, because
Yes.
in terms of the boundary settlement dispute executed with, in terms of the boundary settlement dispute dated 24/6/2023, executed between the appellant and the respondent village. The present appeal petition number 9 of 2019 is accordingly posted. This court extends gratitude to Mr. C.T. Jamir, the learned counsel, the learned senior counsel, and Mr. Takamasa, the learned senior counsel, who acted as the mediator to resolve this long pending issue, which was continuing for almost 85 years. The boundary settlement dispute dated 24/6/2022 shall form part of the record of the case. The writ accordingly stands disposed.
Much obliged.
As many as 5 reverends were present on that day also, on the day of settlement.
But this is a very great achievement. This is a very great achievement because in our state, once actually a boundary like dispute persists, it is endless. Even for that matter, Learned Senior Council
Yes.
will remember Jack K. case. I think it is still
Kyoko
continuing.
is still pending.
See, it
Let
is, I
this
think,
case
about
be
50,
an
60 years.
let this case be an eye opener for the
Yes,
other
yes,
cases as
exactly.
well.
Yes, and thank you. And thank you so much.
On that day also, a lot of praises were made in favor of 2 of us, but I said no. We should all thank God for giving wisdom to the 2 villagers.
Correct.
And they have arrived to an understanding. That is because of the wisdom given by the Almighty. So it is not our achievement, but it is through the Almighty God who has given wisdom to the parties. That's how it has arrived to an amicable settlement.
But Lordship, this should be an indicator whereby this honorable court also should advise in the other
Encourage.
cases
Correct. Of
to
course,
make
of
an
course.
action.
Encourage
Of course,
and
Encourage.
without actually acting as a stumbling block to the income of the lawyers.
Obliged, Lord.
Okay, thank you so
much
much.
Lordships.
For orders, item number 6.
Your
Yes,
Lordship,
please.
I'm appearing on behalf of my senior advocate YP Gupta, the
YP
petitioner.
Gupta.
Petitioner.
Why YP Gupta, he is constantly absent. Is he sick?
Yes, he's not well.
He's not well.
Yes,
So he is for the appellant.
of petitioner.
For the,
Yes.
for the appellant.
Yes, appellant.
Okay. So,
So the service is awaited. We have submitted the copy.
pardon?
The service service is awaited. The copies have been submitted for both the WA and IA.
Have you taken steps?
Yes, just the copies have been submitted, and we are just awaiting for the service.
Okay, receive service report status. Okay, okay. Office note dated 26/6/2023 shows that return service report still awaited. Stop. Awaiting service report listed after 3 weeks.
Much obliged, Your Honor.
Lordships, in respect of item number 7,
Yeah.
in the records, the copy which has been submitted is original copy.
Oh,
So
okay.
if an original copy of the settlement agreement is placed on record, if original word is
Okay,
mentioned,
Okay. Okay.
otherwise
Original
parties may later on say that where is the original
Okay.
copy? You know.
Last slide, the original copy of the settlement so-and-so is placed on record. Is, is placed on record, okay? Original. Okay.
Only the word original should be inserted.
Okay.
Like,